So, Dahlia, and obviously this has been a monumental week at the Supreme Court, and monumentally bad for a whole host of folks and for issues. So what I want to do is I want to go over some of these cases because I think in some respects, these rulings got subsumed by the major announcement by Anthony Kennedy that he was resigning. And then we will talk about the implications of that resignation. But we had four cases over the past week, if I'm not mistaken, that were are going to have a huge impact on our society. One was the Janus v. AFSCME case. This was about public sector unions. One was the upholding of the Muslim ban, and the reasoning here was sort of shocking in light of the master piece cake homophobic baker case. And one was about voting rights, particularly districts in Texas and North Carolina. And then one was about the ability of states to pass laws that make sure that fake prenatal clinics advertise what they really are. So you start with me. What do you think of those rulings, Dahlia, that is the most important for us to be aware of, if Anthony Kennedy had not resigned?
Well, I think that they're all horrific. Like you said, there was not one good ruling there. And I think one coda to the term is that to the extent that progressives have thought that Anthony Kennedy was a centrist or a swing voter, he certainly didn't swing. In these last couple of weeks, he voted rock solid with the 5-4 majorities in each of those cases that you described is really, really incredibly consequential. I think that in some sense, Janus, which is the union financing case, is the most consequential only because it is going to literally kneecap public sector unions. There's no way around that. I think it really foreshadows a grim future for all unions in this country. And I think that it kind of slid under the radar. We didn't get a chance to chew on it at all because the retirement happened within hours. And so I think in terms of look, we can talk about the Muslim ban. It's unbelievable and harrowing. But I think that in terms of the day-to-day lived life of American labor, the fact that the court cavalierly, Sam, just knocked away a 40-year-old precedent and said, that's not the law anymore, and destabilizes unions going forward. I think that people are going to feel that. And it's of a piece with this larger effort. You mentioned the racial gerrymandering case, but all of the voting cases this year, every single one of them was a disaster for progressives. And so I think when I look at the landscape and I want people to focus on what happened at the end of the term, I would say think about the fact that the court not only blessed that Texas racial gerrymander, but also kicked away the two political gerrymandering cases. Those were meant to resolve the constitutional question around political gerrymandering. The court refused to answer that. They blessed an Ohio vote purge case that essentially said Ohio could toss people off the rolls for not voting. All of those taken together, I think, tell you that to the extent that we believe that power is being concentrated more and more in the hands of the powerful and the plutocrats, and that more and more the voices of little people are being edged out, all of those voting cases plus the union case, I think, is the thing to watch.
Yeah, it's fascinating because when you look at these cases, so much of it is about, raw, almost electoral politics. You mentioned that in this Janus v. AFSCME case, which is sort of the next version of the Friedrichs case, which was very similar, but Antonin Scalia, when he passed away, essentially and changed bodily form, left us in bodily form, left public sector unions alone for at least until this Janus case showed up. But the statistics show that where there is so-called right-to-work laws, where unions have been statutorily defunded, we see Democratic vote tallies anywhere from like 2 to 3% less. Just tell us what was involved. You said that it reversed a 40-year precedent. You're talking about the Abood case. Just tell us briefly what Janus means for public sector unions.
Well, the short version of it is, and it sounds technical, it's actually not that technical, that there were claims being made 40 years ago in a case called Abood that said when workers have to pay fees into public sector unions, that violates their First Amendment speech rights. They are being compelled to speak. In Abood, the court said, in a unanimous opinion, by the way, an opinion that even Antonin Scalia had no problem with, the court said, you know what, we're going to make a distinction between the money that is paid by workers to unions that go to political activities, lobbying, organizing, that stuff, that is speech. And then the court said, but we don't want free riders. We don't want people who are going to benefit from the collective bargaining activities of a union and who don't pay in. And so the court created a distinction that lasted until this week that said that you can compel union members to pay in only for collective bargaining activities, not for political activities. And as you said, in Friedrichs, the court had the opportunity to do away with that. Sam Alito has been gunning for that distinction. He's been making the claim for years now that he's been making the claim for years now that distinction is artificial and that even paying toward collective bargaining constitutes compelled speech. In the Friedrichs case, Justice Scalia died while the decision was still pending. He had heard the arguments. And then the court kicked it away, tied 4-4, and it came back this year in the form of the Janus challenge. And for the first time, Sam Alito, writing for the 5-4 majority, says, nope, we're doing away with any compelled fees, even towards this neutral act of collective bargaining. And I think the effect is that folks are not going to pay into unions for collective bargaining. We're going to see millions and millions of dollars that get stripped from the coffers. But more urgently, I think it signals a way forward for private sector unions. And if you think about I think if you see it in the context, and this is Justice Kagan wrote a very frustrated dissent in this case, about this idea of weaponizing the First Amendment, Sam, using these speech claims to absolutely eviscerate laws that, for whatever reason, whether they're protecting workers, whether they're protecting the civil rights laws that protect the gay Americans, whatever it is, she says, we are slowly using these speech claims for very attenuated activities, and we're using it to dismantle all of the legislative protections that have protected the most vulnerable. So I class it with those cases. I class it with the cake bakers and the crisis pregnancy center case you just cited as one of those places where the court takes an idea about what is speech. This starts with Citizens United as well. And it says that everything is a protected speech act, and therefore we can dismantle protections that exist for the most vulnerable. This is one of those.